Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at an important book which has come to us from Stephen Mason. I've reviewed this book before, I did it some years ago. It's called Electronic Signatures in Law, an important area of law. This book is now the 4th edition. Stephen has been able to obtain publication through the Institute of Advanced Legal Studies and Humanities Digital Library. And it's an important book in its own way because of the way in which our society is going with digitisation on the scale we've never seen before. Now, Elizabeth and I talked about this book in some detail, and we came up with the title for our book review, A Well-Established Work of Reference on Electronic Signatures, now in a 4th edition. And I say that because this particular book, when it first came out, I thought it was fascinating because that was in the days where the adducing of evidence was really rather different from the way it is today, because electronic signatures frankly didn't exist in the way they do now, and everybody is using them now, of course. This is the book anyway. There's the front, it's paperback, okay, there's the spine, and then there's the back of the book there. You can just see the detail there, and then at the bottom it shows the people who've been involved. Now I'll just go to the back of the book. It runs to 400 odd pages. The index at the back is page numbering, so you should be able to find things quite easy. It's quite a good index actually, reasonably detailed. And we just get to the front of the index there, and then you've got the book itself. And you can see with the structure, the chapter numbers, there's paragraph numbering, and you've got footnotes at the bottom, which you can probably see there. Now we go to the front of the book. There's the actual front page. Stephen Mason, of Middle Temple Barrister. There we go. Now there are 17 chapters in total. You can see the chapter heads, the detail about the book then, and the information available here. It's a paperback, as I say. Do read the preface, which I think is very, very important. Will set the scene nicely. He says with the 4th edition, the time is right to separate out the different forms of electronic signature, giving each a separate chapter. And obviously he's looking at it from a very sensible point of view, if I may say so. And there's the detail that goes up there. And after that we get to acknowledgements and tables of cases. And then after that, there's not a lot of case law. It is actually, remember, the case law is across the world, so it's not just about one country. It's got an international flavour to it. And it's actually the way that the cases are structured are by state or country. Then there's some legislation, again, setting out from various countries the type of legislation involved, because we are now in a global community, and we have to recognise the way we do our business in the future is going to change. We start off with the main work. There we go, the signature itself, chapter 1, and you've got the paragraph numbering, as I say, and then you've got the footnoting. Then it just runs all the way through. You can see there's a huge amount of detail. This is a very detailed book, and I think a very important one for the modern practitioner. Now, the reason I say that is because a quick perusal of the book should convince you that signatures are not as simple as many people may think. They can manifest themselves in any number of forms, which means that the term signature can either loosely or precisely be defined to the point where it almost defies definition. As a result, says the author Stephen Mason, judges have been required to exercise their powers to test the definition of a signature and see what is acceptable in the legal context. And that really is what the job of the judge is going to have to be, where there is a difference of view. Because, of course, signatures, past and present, medieval and modern, are therefore discussed in detail in the first chapter of this new 4th edition of what has become a long-established practitioner text on an often vexed subject, thus putting the matter of electronic signatures into some form of perspective. Being published now, of course, this book by the Institute of Advanced Legal Studies, an excellent organisation, and it deals with the different forms of electronic signatures, giving each a separate chapter now that the case law has significantly increased. And I'm sure it's going to, as people argue about what is happening, because it's a new era, it's a total new era, and it's a new area for us, and we need to know what systems we have in place about how we interpret things. Now, an acknowledged authority on electronic signatures, the author Stephen Mason, has published widely on the subject, and he reminds us of the differences between the digital and physical worlds, that some forms of electronic signatures may not be considered, strictly speaking, as signatures. Nevertheless, he adds that it's a convenient shorthand to refer to some forms of agreeing to enter a contract as an electronic signature. Now, we've all done that if you use the internet. Think about it, that is what happens. Just think about the concepts of the law of contract for one moment, and you can see why we are looking ahead a little bit at how the whole sort of jurisprudence of contract law. At least we can all understand the meaning behind their words, in other words, electronic signatures, even if the form is not quite what we expected. For instance, is a PIN, for example, an electronic signature? Well, in my view, it probably isn't, but the author argues that it's a form of one because it provides verification or authorization of a transaction. So we're moving ahead from just writing it down and saying that's a signature. So it's numbers. So you see, again, there's a different approach. But it is, I think the words are, provides verification and authorization. And those, I think, are the key words. From here, the book then sort of moves progressively to a more detailed and more technical basis, covering, for example, electronic sound, typing the name into an electronic document, and an email address. Remember now how many things we do where we have to have a password, and at the moment it's got out of hand. Someday they're going to be a bit more sensible about it, but at the moment you've got PIN for this, password for that, and it's very, very difficult for many people to handle that, frankly. It's also not very secure if you think about it. Obviously there are other ways of doing it, but we'll come on to those perhaps another day. Then there are the issues relating to PINs and passwords, which I've just said, and the chapter on liability, evidence, digital signatures and data protection, and of course much more, including a chapter on international initiatives, I think is to be welcomed, because this is an innovative book for the 21st century about some of the problems we're now facing today, not even a few years ago, but very much what we're facing at the moment. I think the book is certainly distinguished by its clarity. It reveals the complexities and the possible and probable pitfalls inherent in the usage of electronic signatures, explaining and analysing relevant case law from an amazingly broad range of jurisdictions. And as the internet knows no boundaries, neither does the matter of electronic signatures as far as we can see. And I think that's going to be right. But I would get back as a test, if you like, to a very basic point about what is the purpose behind it, and that is that it provides verification and authorization. And that really is what the purpose of the signature originally was, to authorize something. But it also identified you as the person doing the authorising. So if you think about it, that's the logic of it. And I don't find a difficult piece of jurisprudence with that at all. With a view to the needs then of the practitioner, the book's logically structured with numbered paragraphs, detailed index, and a wealth of reference, via extensive footnoting. And the table of cases and legislation, about 60 pages of the book, does go through country by country and sometimes state by state particular cases or statutes or pieces of legislation. And it indicates, if anything, the continually changing realities in this area of law, which has come about in response to rapid changes in electronic technologies. I'm very grateful that Stephen's got this published, because I think it's a very important contribution to what we're doing today in the law of evidence, apart from anything else, because this is not going to go away, this subject matter, and it's something we've got to deal with, and we've got to have some fairly robust rules, I think, in place to know what is and is not acceptable. Let me finally say that commercial and industrial laws, I think in particular, will doubtless be keen to add this to the latest edition to their long-established works of reference in their professional libraries, because electronic signatures are, I think, very important. As you might be expecting, the book is also available online. The publication date is cited as September 2016. I haven't got any information about the online version of the book, and I don't have any, but I do have a website which is IALS, as the Institute of Advanced Legal Studies .sas.ac.uk. So it's the academic website, which should give you that information. Let's have a look at the book again anyway. Let me just remind you, that's a structure, and it does deal with pins. So if you have a problem, for instance, with a case involving pins, I think it's important to know what it says in this book. The I accept and wrap methods of indicating intent, because it is really about evidence and intention at the end of the day. Let's open it up in the middle. Here we go. This is a book here in the middle one. This is England and Wales, Northern Ireland and Scotland jurisdictions concerning electronic signatures and the electronic seal. And I have to say, which is something I mentioned at the beginning, for instance here we've got the United States of America. We have a global economy, everything is very much linked now across the planet. So therefore, we've got to have something which has got an international link to it throughout, because things are not going to go back to the way they were. I know the Brexit people think that sometimes, and they're daft, because the answer is you cannot turn the clock back, but you may want to move it forward and reform if obviously, as they think, the EU is kaput. You've then got to move ahead and be more practical about what you're going to put in its place. But I think even with things like electronic signatures in law, we are looking very much at the moment at the way that we are going to have to do our international business in the future. Obviously language comes into it as well, but I think the basic provisions are here, and we will look forward, Stephen, to a 5th edition. Thank you for producing it anyway. Bye-bye.